Right. So thank you again for joining us today. The session is providing a FAPE lessons from the due process hearing front. I'm joined with Mitchell Yell and David Bateman. They are both advisors in the Progress Center. And I'm going to turn it over to them in a little bit to talk more about this topic. Before we get started, we just wanted to introduce some Progress resources that relate to this topic as well. We have a self-paced training module called the Introduction to Federal and State Laws Impacting Students with Disabilities. This is a short 30-minute self-paced training module that explains the difference between civil right laws and funding laws. It identifies where the Individuals with Disability Act or IDEA fits within the continuum of federal laws. It identifies other federal laws that have direct implications for students with disabilities, and helps you understand how state laws may expand federal laws impacting students with disabilities. And we'll drop the link to all of these resources later throughout this presentation. Next slide. And we do have another self-paced training module on the Progress Center website as well, Introduction to Special Education Law, Understanding the Sources of the Law. Similarly to the other module, it is a 30-minute self-paced training module. In this module, you will identify and describe the primary sources of the law in the United States, explain the relationship between federal and state laws, as well as better understand the impact of the role and levels of the adjudicative source of the law. And with that, I'm going to turn it over to Mitch Yell, and he is going to get us started on today's presentation.
Okay, well, thank you, Riley. David and I thought that probably since we're going to be talking about free appropriate public education, that would be a good place to begin with actually defining it. And we want you to understand that's really the primary requirement. The crucial obligation of special educators is to develop and implement an IEP that confers a free appropriate public education. Now, in the next slide, you can see that the definition of a FAPE is unchanged since the original law was passed back in 1975, the Education for All Handicapped Children Act, and essentially says a FAPE is special education and related services that are provided at public expense, can't charge. You put it in the IEP, it's the responsibility of the school district. Must meet the standards of the state education agency. Some states have rights, grant rights to kids with disabilities in excess of what the federal government does, and you have to make certain that you follow them. And I can give you a real quick instance of this. I'm from South Carolina. The federal law requires that transition services be provided at age 16. South Carolina requires age 13. So we have to follow that because it's a standard of our state. Now, the state cannot provide less. They can only provide more. More rights, not less rights. It includes preschool, elementary, or secondary education, and finally is delivered in conformity with a child's or student's IEP. Now, the IEP thus really becomes the real touchstone of what a FAPE is, because you develop that. You and the child's parents develop that together. Now, as you'll notice, the law doesn't really say what appropriate is, and that's by that there was a reason for that Senator Robert Stafford in 1978, who was actually a senator from Vermont, a co-sponsor of the original law, said in Congress, we did not even attempt to define appropriate, but instead we established this baseline mechanism, the IEP. So the IEP is obviously how it's going to be the blueprint of a FAPE for any given child in special education. Now, in the next slide, we can see that the primary requirement, oops, excuse me, I'm going the wrong way. Because appropriate has not been defined, it's what is called a kind of statutorily gray area. And when this area is sort of gray, it's really not clearly explained, so it often falls to the courts to provide an explanation. And in 1982, a case out of New York made it all the way to the Supreme Court. And that case was called Board of Education of the Hendrick Hudson School District v. Rowley, and involved a young girl who was profoundly deaf, and had just entered school, and the parents wanted her to have a sign language interpreter, and the school did a very good job of having an IEP meeting and providing services, but they stopped short of providing a sign language interpreter. So she sued under the law, went to a due process hearing, and ended up going to the federal district court system finally to the Supreme Court. And the question they presented was, what is the level of educational benefit that school districts must confer on children with disabilities to provide them with a FAPE, or with a free, appropriate public education guaranteed by the IDEA? Now, so they were saying, well, the law doesn't really say what's appropriate. Here's what we think it is. We think it means that you will develop a program that allows our child Amy to achieve to her maximum extent appropriate, or maximum extent, and that she receive an education equal to all other children. So that wasn't really answered in the law itself. So the Supreme Court had to answer that. And in a footnote, they said, we could have wished for a little more of a definition, but this is what we got, and we have to use this. So what the Supreme Court did is they created a two-part test to determine if Amy was actually receiving a FAPE. They said, first, we have to determine, did the school district comply with the procedures set forth in the law? Okay, these procedures are very important. And the Supreme Court rightly noted the IDEA is filled with procedures that we have to follow. So that was their first question. Did the Henrik Hudson School District comply with the procedures set forth in the IDEA? And in fact, the Supreme Court found that the school that Amy attended, Furnace Woods Elementary School, had done a very good job on the procedures. Therefore, they passed the first part of the Rowley two-part test. But then the Supreme Court had put in another part, and the second part had to do with the amount of educational benefit that Amy received from her program. So the question the Supreme Court put in the test is the following: is the IEP reasonably calculated to enable the student to receive educational benefit? Well, when they turned to answering that question, Amy, being a very bright child and had a measured IQ of, I think, 125, she was academically able, one of the best students in the class, and was passing from grade to grade. And so they said, well, clearly Amy must have received educational benefit because she was passing from grade to grade. Therefore, we determined that the Henrik Hudson School District met the second part of the test. So because the Henrik Hudson School District met both parts of the test, they prevailed. And many people would say it was a little unfortunate that this was the first test ever heard by the Supreme Court of special education, because Amy was not a typical student that we get in special ed. Like I said, very bright, very academically able. The Supreme Court also mentioned in a footnote, our test, the way we applied it with Amy passing from grade to grade, really only applies to Amy. This test had to be applied with every student when you're testing FAPE, so when you're determining if a school has met FAPE. So as we'll talk about later, both David and I have been hearing officers. If we had a FAPE case prior to 2017, this is the test we had to use to determine if the school district had followed FAPE. Now, what happened is the first part was very easy for most school districts. They just looked at the procedures of the law and they said, did the school district follow these? The second part did not prove to be that easy. So in the next slide, what you see here is different FAPE standards. This is a map of geographic boundaries of the different circuit courts, which are the courts right under the Supreme Court in the federal system in terms of importance. And you'll see there's 3 circuits that used a higher standard. Actually, the circuit that David used to live in had a higher standard where they used the term meaningful benefit. For a child for a hearing officer or a judge to apply the two-part test, the second part of the test was meaningful educational benefit. In these circuits, the fifth, the sixth, and the third, a hearing officer or judge would have to determine, did the school offer a meaningful benefit, educational benefit. Then if you look at the others, there's five other circuits in green, and those circuits developed a lower standard. Those a fair amount lower than the meaningful benefit standard. It was closer to some benefit, trivial benefit, those sorts of things. So they're not as high. The Ninth Circuit, they actually were all over the map. Some of the courts were saying, some of the panels were saying high, meaningful, some were saying lower. So they were very confused in that way. Well, anytime you have a difference between circuits like this, it makes it much more likely the Supreme Court is going to hear a case. Well, because they had a difference in the interpretation of the second part of the Rowley test, that made it likely the Supreme Court was going to hear another case, and that happened in 2017, and David will talk about that.
Thank you, Mitch. And I appreciate how you articulated that. There were differences between what was going on. And the fact that there's also the phrase in between the various circuits, but there's also the phrase that bad facts make bad law. And so we had been living with how to define appropriate based on a very low incidence disability, a child who's deaf, with a very high IQ. I'm willing to bet that the vast majority of you have not worked with individuals who are deaf with high IQs. I did once, and it was a great challenge to me, but we needed a case to help us clarify exactly what we meant by appropriate. So here are some pictures from the Andrew case. The Andrew case was heard in Douglas County South School District, which is the district just immediately south of Denver on I-25. And these pictures are taken at different times of the year. It's not like one is snow, one is green as a result of this, but the parents, Drew attended the Summit View Elementary in Douglas County, the school to the left, and the parents were seeking reimbursement for him to attend the Firefly Autism House, which is located in southern Denver. And they were basically saying that he was not receiving an appropriate education, that the goals had not been changing. There was nothing really done to address his increasing behavior problems. And they placed him there. And in fact, it was a tuition reimbursement case, which one of the parts of questions of any tuition reimbursement case is whether the child's receiving an appropriate education. And so as the courts heard this through the litigation all the way up before the Supreme Court, they were affirming the district's presentation that they were doing exactly what they were supposed to be doing. And so they actually appealed this all, the parents appealed this all the way to the Supreme Court. And the Supreme Court does not hear many cases in special education. And I'm very serious about them. They did hear a case this past year, but that was done a case that probably won't change much of what you do on a daily basis. And the previous one was in 2017. So there's not many cases in special education that are appealed to the Supreme Court. And I'll be candid with you that as a hearing officer, there were times when parents would say, I'm going to appeal this all the way to the Supreme Court. I wanted to be a part of a case that made it to the Supreme Court as a hearing officer. It never happened. And I had several that made it to the Third Circuit when I was working in Pennsylvania, but it was, I wished. But the 10th Circuit is the case where this one was heard. And what we had here is basically the benefit standard must be merely more than de minimis. And so it was barely, which basically means barely more than nothing. And there was all sorts of problems with how the IEP was progressing or not progressing for him, and the behavior problems, and his behavior problems are escalating. And you may be aware of this, as kids grow, they get larger, and it becomes increasingly difficult to actually deal with some of the behaviors that they manifest. So it posed a problem for him, and it posed a problem for the school district as a part of this. But the parents appealed this, and this is the question that they presented to the Supreme Court. And this is a question that we needed based on, as Mitch very nicely articulated, how different things were. And I'll be candid with you, for almost 3 decades, I lived in Pennsylvania, and we would have families who had moved to Pennsylvania from other states. I lived in Carlisle, which was the home of the U.S. Army War College. And we had families that had moved there from some of the low circuits, and they were there. And it was amazing how different they talked about the education that their child was receiving at the time. And then we would find that families would then, because they only come to the War College for 1 year, they would then be posted off into the Pentagon and other locations, that families would stay there because it was the first time that they realized that their child was receiving an appropriate education. And it really did change a lot of what's going on, but this is now a national thing that we need to pay attention to and something, but you can see this. But what is the level of educational benefits school districts must confer on children with disabilities in order for them to receive FAPE? And that's an important question. The Supreme Court granted what's called certiorari, heard this case. There, Mitch and I are, back that 6 years ago. We've changed a lot since then, haven't we? We've changed, and we're both better looking, which is really cool. Is that we've changed a lot, we've improved, we're better, faster, stronger. And so what's interesting about this, we tended the oral arguments for this and listen to what the Supreme Court did say about this. And what's interesting about this, and I don't mean to dismiss this, but what I share with you is that the parents, as a part of their case, were demanding that all kids make a year's worth of progress each year. And the Supreme Court, and why I go back to this, look at this. If you ever get the chance to go to oral arguments on something that you know something about, you will be very impressed with how very well prepped the Supreme Court justices are. I mean, they were spot on. It was the only case they heard that day. They were very spot on with their very prescient questions about the needs, how to do this, implications for this. And so if you're ever lacking in your faith in what's going on in government, go there. They're very well prepped to pay attention to this. What was interesting about this, so about 2 months later, about 6 years ago, the Supreme Court issued a decision that rejected the barely more than de minimis standard. And that's what's important. They rejected this and they remanded the case back to this. But pay attention to the second half of this slide here. To meet its substantive obligations under the IDA, a school must offer an IEP reasonably calculated to enable a child to make progress. It's no longer benefit, but to make progress in light of the child's circumstances, which is important. And Chief Justice John Roberts asked this question multiple times of the parents' attorneys when they were saying this, because the parent was asking for a year's worth of progress each year. And he said, what about kids with really significant disabilities? He was more articulate in it than I was, but he was basically asking these questions. So basically progress based on the student's level, things like this. So keep this in mind as we talk about this, because we're going to use this to reflect on where we're going with this so we can have a better understanding of this. But we've highlighted some words here for you. And so you may be able to pay attention to what the highlighted words are. They may stand out and jump out at you. But the IEP must enable the child to make progress. After all, the essential function of an IEP is, and pay attention to how I parse these words out, is academic and functional advancement. It's not just academic advancement. And so what we have to think about this is how are we going to push these kids forward? How are we going to encourage them? How are we going to move them forward as a part of the system? And it's so that they actually receive an appropriate education. And that's what it's good. But it's not just academics, it's also functional performance. Because too often we negate the functional performance because it's hard. Some of these things are hard to measure, and the behaviors, and there's not standardized ways of actually encountering how many times the student engages with others during the course of the day, or how much off-task time. There's not like a quick Ames web thing that we can use with them to make these determinations. But those are important variables that are often posing problems for these kids because we're not doing a good job of training general education teachers to help them understand what their roles and responsibilities are in provision of these services for these kids. So keep this in mind as we talk about this. And keep this in mind as we address this, okay? So Mitch earlier highlighted what was happened as a part of the Rowley case. We had the Rowley two-part standard, and that was from 1982. And some of you don't remember 1982, but don't raise your hand because that just pisses me off. What's interesting about this is 1982, yes, was a good year, things like this. I was in college, but pay attention to this. The first is the procedural part. Has the state complied with the procedures set forth of the law? This is, again, why your special ed directors hound you to make sure that you're following the timelines, that you have the right people in the room. The thought behind this is that fair procedures will provide fair outcomes. And so if we all follow fair procedures, we're going to have fair outcomes that will help us as a part of this. The second part, and this is going to be the hard one, is the resulting IEP reasonably calculated to enable a student to make progress appropriate in light of his or her circumstances. And so the term is that we're obligated to provide an appropriate education. We're not obligated to do a best education. And that's something that we need to pay attention to. And that's where a lot of the antagonism exists between parents and school districts because of the push-pull, because parents often wanting what's best for their child, and our legal obligation is not to do what's best. Our legal obligation is to do what's appropriate. The problem is appropriate is often in the eye of the beholder. But so we're going to emphasize some points that will help you clarify this, because many of the cases that I've been involved in this past year are not procedural ones. They're not procedural ones. I can count days. I can tell you if the person's in the room. I can tell you if they have the right information, those kinds of things. It's whether the kid is making progress. And that's the important part, okay? So the final part of the Ender case is the parents appealed this to the Court of Appeals heard this. The District Court of Colorado was appealed down, and they basically determined the IEP was not appropriately ambitious. And after 7 years of litigation, Drew was still in school, the Firefly Autism Schoolhouse, that the school district of Douglas County paid a lot of money to help move this case forward as a part of this. So when we talk about this, is that the implications of this, that there's a lot that we need to pay attention to and a lot we need to have to address. And so keep these things in mind, because there are increasingly people who are pursuing litigation in special education because they feel that that's where the money is. And because if gen ed, you sue about gen ed, you're not, there's not a guarantee to services. There's not a right to services, such as in many states. So there's not an obligation for districts to have to pay up if their kid is not providing appropriate gen ed services. It's when they're special ed. So there's money involved in this. So I'm going to turn it back over to Mitch, who's going to talk about just the basic process on litigating a FAPE so that we all understand that process. So therefore we can talk about the recommendations we're going to make as a result of this. Okay?
Okay, so thank you, David. Before we get into that, litigating FAPE, I want to spend a little bit of time talking about litigation, because we live in a very litigious field. We work, I should say, in a very litigious field, that there are often situations in which parents and school districts do not have a disagreement about the child's education, and they cannot settle it. When they cannot settle it, the idea contains what are called procedural safeguards. One of the ultimate procedural safeguards is a parent can issue a complaint. One common way of doing this is by requesting a due process hearing. And as we'll talk about later, both David and I have done this. But after a hearing, there is a whole nother type of procedures that may come about. And in the next slide, what you can see, what we have here is the litigation done the typical way. In the United States, there are this is the federal system, by the way, it's not the state system. Every state has their own system that is virtually the same thing as the federal system. They are sometimes call the courts by different names, but there's always an initial level, an appeals level, and what's called a court of last resort. Now, the reason we're going to be talking mostly about the federal system is probably about 95% of all special ed cases go through the federal system. So this is the way they go. Every state has between 1 and 4 federal district courts. That's often called a trial court. And what happens in the trial court is you have a judge, there's a jury, attorneys present their cases. Now, they're 90, like I said, some states, like the big states like California, New York, have as many as 4 district courts. The smaller states like South Carolina has 1. But if we looked at all of district courts in the United States, there are 94 of them. Now, if a case is heard at that level and a decision is made that decision, the party that loses could appeal that decision, and they go to the next higher level of courts, which is the U.S. Courts of Appeals. There's 13 of them in the United States. And here are the different circuits. And David was always quite confused seeing Guam and Alaska both under California. And we had to explain that, no, they're not there. That's just for the picture. But these are the different circuits. And you can see they start up in the first, go all the way to the ninth. Now, David used to live in the third. Now he lives in the fourth. I live in the fourth in South Carolina. Now, every one of those states has at least one district court. So South Carolina, I'll use that example, only has one. If you look real closely, you'll see California has a lot of little dotted lines in it. That's because California has 4. If you look up to Washington, there's a dotted line. They have 2 district courts. So when a case is heard at the district court level, if appeal is made, it goes to the circuit court that state is in. So David and I are in the 4th Circuit. So if there's an appeal of a case in South Carolina or Virginia, it goes to the U.S. Court of Appeals for the 4th Circuit. Now, the final appeal, as David said, could be made to the Supreme Court. Now, they don't hear every case. They hear very few cases, but there is only one of them. But when that is law, when they say something, that's law everywhere. All lower courts have to follow that. And so you see, they're very important decisions. Now, if you look, if we go to the next slide, one of the things we thought is, litigation in special education is special because we have a slightly different system. In most states, there is what is called a local due process hearing will be held. So if a parent files for a hearing, it goes to the local hearing officer. And David did many of those cases when he was in Pennsylvania, and he acts like a judge. Their parents and their attorney are on one side unless they don't have attorney, which is called going pro se. In the school district and their attorney are on other sides, and witnesses are called, exhibits are entered. It's just like going to court. Now, in some states, actually very few states, there's only 7 states, there is a second tier, which means if the person that loses at the hearing, tier 1 hearing, could appeal, but instead of appealing to the court system, it goes to the second review hearing, which is called the state review officer. And he or she reviews it. And that's what I do now for South Carolina, and David is going to be doing. And what we do is sit down and look and read the transcripts of the hearing and decide if the hearing officer made a correct legal decision. Now, if our decision is appealed, then it goes to the courts. So you have the trial court, which is the U.S. District Court, the Intermediate Appellate Court, which is the U.S. Court of Appeals, and eventually all the way to the highest court, the U.S. Supreme Court, which is called the Court of Last Resort, because you can't go any further than that. And you'll notice in the little figure that we have the orange represents states. So there are 3 levels of courts in the state, but because most special ed cases are heard in the federal court system, that's what we'll talk about. Now, the Rowley case and the Andrew case were both heard at the Supreme Court. But most cases never go that far, as David said. Most cases don't actually go beyond hearing or review hearing. And so what we're going to be talking about today is our experience as hearing officers. And it's very important, I think, that we pay attention to due process hearings because for a number of reasons. Number one, they highlight emerging trends in the field. So, for instance, there are a number of hearings regarding COVID. There's very little case law yet. It's going to be coming. And that's because hearings have to be held under a relatively short timeline. Like if David got a hearing in Pennsylvania, I suspect he had 45 days to hear the case, make the decision. If it gets appealed, as a state review officer, I have 30 days to read the case, make my decision. But when it goes to the courts, there is no timeline. So that can take quite a bit longer. But nonetheless, so we often see emerging trends coming first in hearings, emerging trends, at least in special ed. Now, another thing is hearings can set precedents. David can set precedent, which means if courts agree with a hearing officer and render the same decision, that sets a precedent, which means lower courts or hearing officers have to follow that decision. Now, David said he had always hoped he would be heard in the Supreme Court, and it usually doesn't happen. But nonetheless, hearings are important. Hearings are also important because they can be very expensive for school districts. The recent averages that I've read are anywhere from a school district will spend $18,000 to $50,000 on a hearing, and that expense is borne by the school district. And I would say in the last hearing, I would think if the school district got away with $50,000, that was a good deal because it was a very complex case. So it'll heard for 5 days. Attorneys have to go in. David now prepares witnesses. There's money for that. So it's a very expensive procedure. And also hearing officers in either level can use certain remedies. They could order that a school pay tuition reimbursement. They could order compensatory education, for example. The only thing they can't do is they cannot order attorney's fees. That can only be done by a court. Now, if we look at the next slide, what we see is that, let's see. There we go. As hearing officers, David and I have heard lots of cases. I've reviewed a lot of cases. And what we have really tried to break this presentation down into 3 types of school district errors that we're more likely to see. First type, I'll go through these 3 types and then we'll spend more time on them. But the first type is really procedural. And that's David said, that's why special ed directors spend so much time talking to you about the different procedures in the law, because we need to know what the law requires and then follow those requirements. And that was the first part of the Rowley test. The procedures are very important. In fact, there's certain procedural errors that could lead to a denial of FAPE in and of themselves. The second type of school district error is called a substantive error. And what that refers to, really, a substantive error is an error that Julie Weatherly would say is made in the content of the IEP. It's for some reason, there's something wrong with the IEP that's developed, and it just doesn't provide an education that enables a student to make progress. So that's the substantive part. Now, in 2004, Congress, when they reauthorized the idea, they said the substantive part is really kind of more important than the procedural part. You have to get the procedures right. But what is really important is, did the child make progress appropriate in light of his or her circumstances? And that would be using the Rowley's term. So those are the first 2 types, procedural and substantive. The next type is implementation errors. Now, the Supreme Court has never heard a case on implementation of an IEP, but essentially what this means is if the school fails to enact a student's IEP as agreed upon in the IEP meeting, that is an implementation error, and it may be a denial of FAPE. So what we're going to do is we are going to spend some time going over these 3 types of errors. And to tell you what we have found in our experience as hearing officers and reading the case law are what are the most serious school district errors committed. First, let me talk about procedural, and then we're going to move to substantive, and David's going to talk about that. But there are really 4 major procedural errors that we have seen that likely will lead to a denial of FAPE if it is found that the school district committed these errors. And the first error is failing to involve a student's parents in the IEP formulation and monitoring. That is a very, in fact, many people would say it is the essential procedural safeguard of the idea is that a student's parents must be involved in not only developing the IEP, but in monitoring the IEP. Recall that we have to be reporting to a student's parents on their progress. That is monitoring. So that's a very crucial error. That doesn't mean that I was a teacher for 16 years, and I know, and many of you will had this too, you can't get parents, you can't find them, you can't convince them. Well, you still have the responsibility for writing an IEP, but if you have to make good faith efforts to get the parent involved. A second major error is predetermining a child's program or placement. And what that essentially means is you make a final decision, the school makes the final decision without the parents. For instance, they write an IEP and the parent is not involved. And when the parent comes in, they say, here's the IEP, take it or leave it. You know, that would be predetermination. We must never predetermine a child's program or placement. We can have informal meetings about it, but we can't make a final decision until we have the parents there in the IEP meeting. That's where the final decision is made. Predetermination, not good, don't do it. Third, failing to properly conduct child find activities. And this is more of a school district procedure that many school districts will have kindergarten roundups, and there's referral systems to find children. We have an affirmative duty to find students with disabilities. And fourth, one that has really been coming up a lot lately in cases I've done is failing to seriously consider the resolution session. In 2004, there was a step put between mediation and the due process hearing called the resolution session, and it involves the last attempt to meet and make an agreement on a child's program before going to due process, and failing to do that is a very serious procedural error. So those are the procedural errors that we have found to be the most serious and the most likely to lead to a denial of FAPE. Another is if you do multiple procedural errors, even small ones. Courts have sometimes said that multiple procedural errors, even if they don't deny FAPE in and of themselves, could mount up to be a denial of FAPE. So next, we're going to move on, and David's going to talk about the serious substantive errors.
Thank you, Mitch. I appreciate you teeing that up very nicely. The procedural parts are the ones that we all pay attention to, and they, in many respects, they're the easier ones, and they're ones but you need to absolutely pay attention to. The Supreme Court has affirmed both in 1982 and in 2017. But there's some substantive errors that we need to address, and that's the second part. And these are ones you need to pay very close attention to. And we'll get to some quick recommendations in a minute. But basically, make sure that the internal consistency of the IEP, you address the present level statement for me is the very most important part of the IEP, because it dictates everything that what we need to do relating to the child. It dictates then the services, the level, and the actual location where we might be able to do this. But if you don't have a tie between what the present level statement says and the services that are being provided, and either the goals or anything that's being provided to the child, that you don't have consistency with where we are with this. I can't tell you how many IEPs I've seen where we have kids who has all sorts of behavior problems, all sorts of functional skills problems, and there's nothing in the IEP to address said behavioral or functional skills issues. Second one, failing to craft measurable annual goals. Mitch and we co-wrote a textbook on legally compliant IEPs. And what I was doing as a part of that is I'd started a collection of bad IEP goals, but I had to stop because I was afraid that I was going to run out of hard drive space on my computer because I was seeing so many bad goals. We need to make sure that our goals that we're doing are measurable, things that you can do. We're not going to have goals where the kid will think about reading or the kid will consider something. We're going to actually have goals that we can actually visibly see, that you can see, and new teachers can see, your grandmother can see whether this is happening. And then the last one is failing to collect and or report data on a student's progress towards their goals. If there's one thing that we can talk about enough, and the next slide will highlight this also, we need to dramatically increase the progress monitoring we're doing this and make sure that we're reporting this. That'll be one of the recommendations we'll get to in a minute. What we can't emphasize enough is to do this. I've done witness preparation for due process hearings for years. And witness preparation for speech pathologists is always very easy because they take data pretty much every single time they work with the child. I'm not saying that we need to do that, but we need to increase the amount of data that we have so we have clear trends and understanding where the child's functioning, whether that child is improving or not improving as a part of their programming that we're providing to them. So those are important characteristics we need to address as a part of this. Okay. Kathy Mayfield, who just recently retired, who was an attorney in Virginia. And what she said this, and this is an important variable that we need to address as a part of this, is we have to think about is that in FAPE cases, when the districts have things, first thing you have to do is say to teachers, give me the information on your student's progress. And if the teacher doesn't have data, we need to settle. And do we settle often? Yes, we settle a lot. The districts settle a lot of these cases. And I know there's a class action lawsuit against the Commonwealth of Virginia right now because in due process hearings, parents are only prevailing in due process hearings 1.5% of the time, but there's a lot of settlements that occur prior to that. And we need to address that and pay attention to this. We need to dramatically increase this and pay attention and address this matter because it's posing significant problems, not only for the kids, but also for understanding precisely and communication with the parents. And I've seen crappy, I think that's the formal term on the continuum of levels, crappy statements provided to parents so that they don't have an understanding truly of how their child is functioning or what's going on with them. So we need to address this. Further, let's take this further. So substantive is important. The next one is some serious district errors, things like this. Implementation errors, okay? Implementation errors, you have to think about this, is failing to provide the services, the amount of services upon the IEP team. We spend an enormous amount of time developing these IEPs. We bring these people together, we write this, have team meetings, we think about this. Make sure they implement the little suckers. Implement the little suckers with the amount of time that we're supposed to be doing this. So if a child is supposed to receive 2 hours of language arts instruction for reading, spelling, and written language, give that child 2 hours. Don't just do 30 minutes every other day. Make sure that there's a closer tie between what's going on this. But you have to think about this. IEPs, and it's like a contract. It's close. It's not quite like perfect like a contract, but it's like a contract. It's a binding commitment by the school district to provide the services, or in your Virginia school division, but is to provide the services about what we're going to do for these kids. And we need to make sure that we're doing this and we're providing these services for these kids. So keep this in mind as first. So based on this, this is what you've all been teed up for. We're pretty excited because we're going to get to the recommendations. This is where we're going with this. Based on our due process hearing experiences, and Mitch and I have not talked about a due process hearing, at least 24 hours. So we're kind of on a break right now. What's interesting about this is we're considering this. Some of you watch Netflix, some of you watch Hulu, some of you have Apple TV. I'm enjoying the Steph Curry documentary right now. But when some of you are doing these things, we read case law. My wife tells me I need to get out more often, but this is what I enjoy doing. So just trust me in these things like this. But what we have to think about, so we have some clear recommendations that we would like to provide for you that will help you just make it through the day and improve services. First one, and this is not, I don't say this is a low-hanging fruit, but this is one that you need to pay attention to. Understand and avoid the procedural violations in the development of the IEP that could in themselves constitute a denial of FAPE. Big issue, and and a tag on this one. Make sure you have the right people in the room. Make sure that you have the right people in the room who know what the kid looks like. And I say this because I was working with the district this past year where they would have a PE teacher who had no idea what the kids would look like, but was free that period to come to the IEP meetings, have that teacher go cover the class of someone who knows what this kid looks like. It's not a permanent fix, but it's a temporary thing where they would go cover the class so that we at least know have someone who understands what this child's doing, how this child's performing, and can speak to this and understand what's going on. But there are some, but it's the procedural violations that we need to pay attention to. Also, make sure that you're not caught by surprise. That you're not caught by surprise when there's an IEP come due, that you actually start thinking about it several weeks ahead of time and start drafting and meeting with the parents and start trying to schedule these things ahead of time so that they don't have to delay the process. Now, the Progress Center has some really good resources. And for each one, but most of all the tips that we're going to be providing for you, there are some really good resources that can provide assistance for help where they are this. So I highly recommend these online training resources and these IEP tip sheets that the Progress Center has developed. They're free. We can't do any better than this, folks. It's the best we can do. They're free. And so please run with these, take these out and pass them out to your teams. Get them so that they can understand what's going on with them. So that's recommendation 1. I'm going to turn it over to Mitch for recommendation number 2 and let him go at it. So there, okay?
Okay, thank you, David. And you'll notice Riley is putting in links in the chat to these different resources available. And I do want to, before I go on to recommendation 2, just comment. Ellen made a very good comment. I always thought since each hearing is an individual hearing based on IEP and it cannot set precedents. That is correct. If I probably wasn't clear enough. The hearing itself doesn't set precedent, but when it goes to a court, courts could. The best example I can think of is a case out of Iowa a number of years ago called Cedar Rapids v. Garrett F. The hearing officer made a decision that was overturned in the Supreme Court. Overturned in the district court, in the appellate court, went to the Supreme Court, and Bartlett's decision was upheld. So his decision was precedent. The courts actually were not. But the hearing itself does not set precedent. It's the courts when courts start hearing it. And appellate court and, of course, the Supreme Court are the most important precedents. Now, well, let me go on to recommendation 2. When developing content of a student's IEP and reviewing it and revising it, you should be certain that the present levels of performance and annual goals are based on evaluations and current relevant data. In other words, don't use old data. Make certain that you're using new data. Now, in terms of resources that address this area, you'll find, and Riley has put this in the website. There's a really good online training course on goals. So really look at those. Excellent. Now, recommendation 3 is ensure that the goals themselves are appropriate, they're ambitious, and they're measurable. Now, we underline the measurable, of course, because since when I started teaching, we just had to write goals in IEPs. Now as of 1990, we had to write measurable goals. You have to be able to write them and then measure them. And you even have to say how you're going to measure them. They also should be appropriate, and as the Andrew case showed us, they should be ambitious. That you want the child to actually make, if they meet their goal, they will actually be making some amount of progress. Now, the resources there are a number of really good resources that are provided that Riley is going to be putting into the chat, but on both writing academic goals, setting goals, and behavioral goals. And there's an excellent module too on monitoring these goals. And so what we're going to do is move on to David's going to take recommendation 4.
Okay, thank you. And I appreciate the opportunity again to talk with you. One thing and I said this, I alluded to this a few minutes ago, but what I want you to pay attention to is continuously monitor and measure a child's progress and determine whether the progress has been made. I mean, take frequent data points. And how many data points am I recommending? Like, for instance, in a 9-week marking period, I'm recommending 6 to 7 data points per marking period per goal, which sounds like a lot, but it not really isn't, because you have to think about this and conceptualize it as a series of snapshots instead of a series of long videos. And if you take a series of snapshots, you can get a lot of data on a child in a 5 to 10 minute probe about how the child is either reading or doing math or what skills are, or just do some observational things of what they're doing on the playground. You can get really good data on these things. It doesn't have to be a long 2-hour test every time. So get a series of quick probes on this child and graph those that are consistent so that you can have some representation so you can say yay or nay whether the child's making progress. And we have additional resources that help as a part of this, graphing and analyzing the data and where we go with this, and being able to make sure that we have some sense of what's going on with this. But keep this informed about keep the people informed about and understand so that you have data. So if anyone asks where the child's currently functioning, you have a sense. You have a very clear sense about what's going on with the child, and you have a sense of where we are with this, okay? Which brings us to our next recommendation. Wait, there's more, okay? Is provide frequent and systematic data-based information to the students' parents and the child's advancement towards their goals. And make sure that you provide data-based information that they can understand. I have parents who contact me all the time and don't know if a dibbles is something that they can hold in their hand or is it something that they serve at the special school lunch. So you make sure that you explain so that parents understand. Parents often don't understand standard scores. So that you have to understand and explain it so that parents can understand and be able to interpret so that they can be informed about this. This is vital, but provide frequent and systematic database reports. We're obligated to do this at the same frequency that non-disabled kids get report cards. That's important, and I think that's wonderful, but we need to make sure that we provide information that the parents can understand. But I have seen reading data for parents that say, seems good. That's the data that the parents get. That doesn't tell me how the child's actually functioning. You need to make sure that it's understandable for everyone and go this. So we have a short video that hopefully will help clarify this, okay?
Looking at her graphs with her, I feel like we're on the same page because it shows me what her progress is, and it lets me know that she's not just staying at the same level and she's learning something, getting better, and starting to comprehend what she's doing day to day.
So what is important about that is that's from the National Center for Intensive Intervention, and they have a wonderful host of great resources for you also. The Progress Center and the National Center for Intensive Intervention are all under the AIR umbrella, and there's wonderful resources that are available. All of them are free. Again, we can't do any better than free, folks. We're really trying to get you good resources that you can use to be beneficial for your team. Additionally, there's some great resources to help with this, just to help families and be part of the process so they can explain things and understand what's going on. You really, truly need to emphasize getting the parents involved, ensuring the parents are participants and understand what's going on. Too often, like for instance, we often write evaluation reports on kids at a reading level that the parents can't understand. The procedural safeguards notice is written at a level they can't understand often because was it 96% or 48 of the states have procedural safeguards notices written at a college level or higher. So we need to think about what we can do to get the parents involved as a part of this. I'm going to turn it back over to Mitch for recommendation 6.
Recommendation 6 is when your progress report and other data do not reflect that an annual goal will be met, reconvene the IEP team to determine why and make changes to academic and functional aids and services. And that's a problem I'm sure David and I both have seen, is that when data shows that a change should be made, it isn't made. Well, that's not a good thing. You want to make certain that you are reacting to the data. Now, in the next slide, we have more recommendations that Riley, or resources, I should say, that Riley is going to put into the chat box about data teaming tools. There's some excellent resources available. Recommendation 7 is make certain that students' IEPs are implemented in special and general education settings as agreed upon in the IEP meeting. Now, courts will make distinctions between material and immaterial errors in IEP implementation. We should not be doing that. We should be thinking that everything we put in the IEP, we want to implement it as much as accurately as we can. Very difficult, but you want to make certain at secondary levels that all the recommendation, all the IEP is being, all aspects of the IEP is written, not only the services and the supplementary services and the program modifications, but also the amount of services that you said you'd provide. Now, in the next slide, more resources available to you that are really good. And while we go to the next slide, I want to take just a second to answer a question or a query by Mary that our state passed a state law that requires school districts to allow ABA services, but the law is specific that the school is not responsible for paying for these services. Parents want them included in the IEP. The team is, or the school district is resistant to that because they may have to pay for it. That is one of the reasons often people will say, don't put specific curricula in the IEP, because you're essentially, that is what you're going to be having to deliver. So this is really a state issue and not that important. But remember, if the child needs something to make progress, you have to provide it. Okay, we'll turn it back to Riley.
Awesome. Thank you, David. And thank you, Mitch, for sharing all that information and the resources. And I know for everyone here today, we have shared a lot of links in the chat, and it's sometimes hard to keep track of. So I am going to share two that will be most important in keeping track of all the links that were shared today. This first one is going to be the event archive page, where you can find this PowerPoint slide, all the resources, as well as the recordings for this session and all the sessions from Prepping for Progress over these last 2 days. The second link is the link directly to these PowerPoint slides. And this is important because all the resources that we shared today are linked directly in those slides. So if you don't want to keep track of all of them that were shared in this, the chat today, just go directly to that PowerPoint and you can get them from there. But up on this side, there are a couple other resources that we do want to highlight that were not shared yet. These are some modules from the IRIS Center, as well as the Progress Center. I know we dropped those links before, but there are also some great online learning modules from the IRIS Center. This first one is on developing high quality IEPs. An overview of the high quality IEPs. They explain in Andrew F., the Supreme Court decision, IEP process for guidelines and common errors, as well as detailed development steps for IEP content, substantive guidelines, and common errors. Another one from the IRIS Center is also on the IEPs, and it's on how administrators can support the development and implementation of high quality IEPs. This explains the administrator's role in particular in overseeing the IEP process. It describes actions that school leaders should take during, before, and after the IEP meeting. It also explains the legal implications of Andrew F. and includes specially developed info briefs on IEP team member roles, determining LRE, monitoring student progress, and common errors and how to avoid them. Some more resources in case you want to dive a little bit deeper into this topic. Obviously, the Progress Center and the IRIS Center, as well as NCII, we highlighted some here today. We also want to highlight the Special Education Law blog, the IDEA webpage that you can access a lot of resources as well as Understood, another center that has resources on this topic. We also invite you to stay.
David and I, well, I was just going to say, David and I do the law blog, and we try to update it about every 2 weeks or so.
Awesome, thank you. And then we do just invite you to stay connected with the Progress Center. You can stay connected with us on Facebook or on Twitter at K12 Progress, as well as joining our mailing list so you can stay updated with all the most recent updates for the Progress Center. You can join the mailing list by going right to promotingprogress.org, entering your name and email to ensure that you're staying updated at all times. And that is all we have for you today. We thank you for joining this session, and we hope that you found this information useful for you and your role in your work. If there's any last questions for David or for Mitch before we hop off here, we welcome you to either put those in the chat or come off mute. If not, that is all we have for you today, and we hope you enjoy the rest of your time at Prepping for Progress, and thank you for joining us today.
Thank you.